Hello, everybody. This is Advocate Lucinda, your empowerment lawyer. Motions. Motions are critical to a lawsuit, whether it's the plaintiff or whether it is the defendant. And I want to talk about a particular motion today, someone concerned they wouldn't get a fair trial. The question was, can I file a motion to have my case moved to another court? Well, the answer to that is yes. A plaintiff who feels that they cannot have a fair trial, or even after they've had a trial, they believe it was unfair based on the venue, they can file a motion for a new venue, and even after the trial has been had, they can ask the court to allow him or her to have another trial, but in a different venue. And of course, that is the motion to change venue. Now, there is a burden of proof that the plaintiff has to show. And we're going to talk about that, what that proof is. But let's make a distinction between the venue and jurisdiction. I am a federal litigator. Federal courts have jurisdiction over cases involving the United States government, the Constitution, or federal laws, or controversies between states or between the United States government and foreign governments. Venue refers to the county where the activity giving rise to the lawsuit occurred, where the organization being sued is located, and where the individual defendant lives or does business. 28 U.S.C. Code Section 1404A provides that for the convenience of parties and witnesses in the interest of justice, a district may transfer sua sponte or on its own any civil action to any other district might have been brought. So, any party, including plaintiff, may move for a transfer under 28 U.S.C. Section 1404A. The reason could be for bias, pretrial publicity, political atmosphere, pre-bias jury pool. That's a good one that I want to discuss later. Any other circumstance that the parties believe would prevent them from obtaining a fair trial in the county in which the case was originally filed. Plaintiff could even move for transfer on grounds of inconvenience. So the question is, when is one inconvenienced to the extent that if venue is not changed, the individual will be prejudiced? Let me give you an example. In this case, Chilingirian versus Fraser, the plaintiff sued the employer under the Whistleblower Protection Act in Wayne County, Michigan. The court granted defendant's motion to change venue, finding there was no nexus or connection to Wayne County. The appellate court reversed the lower court, holding defendant failed to demonstrate inconvenience or prejudice and did not make a persuasive showing. You must read this case. I am going to leave a link to this case on the description page of this video. And I'm also going to leave a link of a sample motion to change venue. So while the plaintiff whistleblower did not initiate the change of venue, the whistleblower did in fact challenge the dealing on behalf of defendant, wherein defendant, of course, filed the motion to change venue. The appellate court disagreed. The appellate court not only reversed, but it made an interesting comment why it reversed. It stated this: with the protective purpose of the Whistleblowers Protection Act in mind, We are not persuaded that the moving parties met their burden of demonstrating inconvenience or prejudice to such an extent that plaintiff's choice of forum should be ignored. The inconvenience caused by travel between two adjoining counties does not constitute a persuasive showing of inconvenience. And of course, this is the argument that the defendant made. It is not persuasive to show prejudice, which would justify a change of venue. Therefore, the appellate court concludes, we find that the lower court abused its discretion in changing the venue in this case. And you need to read this case because it really outlines venue and how it works. I hope this has been helpful to you. And as always, I am Advocate Lucinda B. Empowered.